Everyone, David Coe at the Coe Real Estate Group. Hey, I hope your holiday was a really fun, relaxing time spent with friends and family. I know mine sure was, but I am super excited about what 2025 has in store. We're already off to a really fast start, and I figured it'd be a good time to kind of take a look at some of the new laws that are affecting real estate this year. So let's jump into it. So first of all is AB 2533. This is a new law surrounding ADUs. And basically this is an amnesty law for people that had an unpermitted or illegal structure that they've been using as an ADU, which is short for an accessory dwelling unit, a granny flat, some kind of little rental apartment or something you might have on your property. Now, if you want to legally get that permitted, you can go to your local city and present plans on what you need to do to get that permitted. The city can't automatically reject it just because it was illegal before. So if you have maybe a space and you've been thinking about legally converting that to an ADU, AB 2533 will now allow you to do that. It still has to meet, local building guidelines and setbacks and everything else, but you now have the ability to go and convert that space legally into an ADU. The second one is a bill called AB 2114. This is actually an extension of a bill that was passed a few years ago that requires any structure in California that has more than 3 units, that has an exterior deck, a wooden balcony, stairways, or any structure that sits at least 6 feet above the ground. You now have to have that inspected to make sure that that structure is structurally sound. There was an incident a few years ago where a bunch of students were at a frat party and that deck collapsed. A bunch of people got killed and hurt. So the deadline was set to expire January 1st. This new bill now extends that timeline until the end of this year. And then every 6 years, if it is an apartment building that one person owns, you have to have that re-inspected for safety. And then if it's an HOA on a condo association, you now have to have that re-inspected every 9 years. And then a little bill called, that was actually Bill 2579. AB 2114 is actually now allowing civil engineers to also be allowed to perform these inspections. Another bill that just came out really redefines buyer representation. Now, a lot of you probably heard it with the whole NAR-CAR agreement that we had last year on all of our real estate rules. Well, something that was a rule within our brokerage is now a law within the state of California regarding buyer representation. So now we have to have a representation agreement signed with the buyer at least before we present an offer, but ideally before we even show property. That agreement can't be more than 3 months long. It can't automatically renew, and it has to clearly state exactly what the terms are in case that buyer gets into an escrow with the seller. This does not apply to rentals or leases, but anyone looking to buy a property starting this year in California, by law, you have to have an agreement signed with an agent or a broker. Next up, there's an extension on foreclosures of 1 to 4 units. So let's say a property is going is in foreclosure. It is getting ready to be listed for sale. And as long as the owner or someone presents to the trustee a listing agreement that property is going to be listed for sale, they have to receive it at least 5 business days before the date of sale, but that will automatically extend the date of sale by 45 days. And within that 45 days, if there now is a qualified purchase agreement that gets presented to the trustee, that will now qualify for another 45-day extension. Again, you have to have that presented at least 5 business days before the date of sale. But if a property is going in foreclosure, AB 2424 now really gives an owner of a residential 1 to 4 90 days to try to liquidate and sell that property versus having it go through a foreclosure sale. SB 478 is an advertising with transparency. This is probably something that really affects realtors, although it does affect consumers, because what this does is prevents us from advertising real estate without putting in prices. We have to have all fees, including mandatory fees. It doesn't include taxes and any government imposed fees, but any fees associated with that purchase. And if we're going to promote it, we have to put it in the advertising. AB 2747 was a bill that was all about tenant positive credit reporting. So if you're a tenant or if you're a landlord with a tenant, as a tenant now, you can request that your positive payment history gets reported to one of the mandatory or to one of the credit bureaus. You don't have to do it, but it gives the tenant the opportunity to have that reported. If there's a fee associated with that, a landlord can pass that fee on to the tenant, and the tenant can actually request that the reporting be stopped. If for some reason they're running late on a payment and they don't want that reported, they can request that that gets paused. But if they do that, they can't reactivate it for up to 6 months. So this is meant to help tenants that maybe don't have great credit, and that's why they can't afford to buy. As long as they pay their rent on time, you can now have that reported to a local credit bureau, which should increase credit scores and should help the ability for for a tenant to purchase a home somewhere down the line. Speaking of tenants, a new bill. This one's pretty controversial with a lot of commercial landlords, but the SB 1103 now creates a qualified commercial tenant. Okay, and really what this is meant to do is for small business owners. You have to have a certain a low number of employees to qualify, and it extends some benefits to commercial tenants that residential tenants get. Mostly you get a 30 and 90-day notice to increase the rent. As a landlord, you have to provide that. Same thing if you're going to terminate the tenancy, you have to give a 30 and 60-day notice. And if that tenant speaks a couple of different languages, all the communications with that tenant has to be in their primary language. It's up to you, the landlord, to get all that information translated and sent to that tenant. SB 552 is a new law about some pool safety features. So if you have a pool or thinking about having a pool, pools must now have 2 of 7 safety features within that pool to prevent drowning. And this year what SB 552 did is it actually added removable mesh fences, pool safety covers, and alarms to the list of available safety features. And whereas before there were 5 and you had to have at least 1, now moving forward you have to have at least 2, but they gave you a few more choices to pick from. And same thing if you are if you're buying a home and it has a pool, now your home inspector is required to identify any of the safety features that are available, or they have to identify the fact that there are no safety features. So that's now a law that passed on January the 1st. So hopefully this has been a good overview of some of the new laws affecting real estate in 2025. I did put a link down to a CAR article that has all the new bills with a lot more details on these. So if you want to learn more, please click the link below. And if you have questions about maybe how some of these laws affect you, we're also here to help, answer any questions you might have. So hopefully this was helpful. David Coe with the Coe Real Estate Group. I hope this finds you well. I hope your 2025 is a huge success. And most importantly, I hope to talk to you soon.